Welcome back to the Dean Obeidallah Show. Right now, very happy to welcome for the first time on this show someone you've seen as a guest and host on MSNBC, Charles Coleman, MSNBC legal analyst, a former prosecutor, a writer for Slate, and does so much more at MSNBC, hosting documentaries and more. Charles, welcome to the show, my friend. It's great to have you on.
Dean, it is good to be here. Thank you so much for having me. It's different being interviewed by you as opposed to interviewing you. So I'm looking forward to this.
Usually I'm sitting next to Molly Jong Fast, and the whole thing is you trying to get her followers on social media. So this is actually, we're not talking about Molly. I just had Mary Trump on 2 days ago. That's my person I try to get followers from. Mary comes on all the time. She's my buddy. So let's talk about this, the first week of the trial. It
Yes.
actually began. Donald Trump tried to stop it, did everything he could. It happened. Any surprises for you that you really didn't expect that we've seen play out this first week?
I'm surprised that they do, as of today, have a full jury and we're on to the alternates. I did not think that we would be able to get this far. And it was sort of an up and down. We started with seven and then it went down to five. That did not surprise me because I felt like that was more akin to what the real world is like when you're talking about trying cases. Also, not surprised necessarily that Donald Trump's stamina as a defendant to be in court and be at trial. He's fallen asleep a couple of times, is not what it is. What I will expect, and I will tell you and others to watch for, is that this guy is not going to be able to keep it together for 6 weeks. And what I mean by that is like I really do expect fully that he's going to, whatever contours are set around this gag order by Judge Marchand, he's going to violate them. And he's going to
Mhm.
violate them because he's not used to having to sit somewhere contained and composed for as long and as often and as frequent as you do at trial. It is a grueling thing as an attorney, both mentally and physically. And this is going to wear on him. The pressure is not going to go down, it's going to go up. And eventually, I fully expect that he's going to pop and really just go ballistic on social media, if not in the press, because he's not someone who's used to having a narrative about him put out without being able to respond. And his hands are tied a little bit. So I'm watching for that. But if you're asking me what I'm surprised about most, it's probably the fact that we like really do have a jury in this case.
We could start opening arguments next week, depending how it works out with the alternates and every other housekeeping the judges do before a trial. One of the housekeeping issues is the hearing scheduled for Tuesday on the gag order. And the prosecutor said yesterday that Donald Trump violated 7 more times since their first application. What is the right result? Forget who he is. Just in a normal case, what would be the right result for this kind of gag order violation?
I think generally speaking, you're absolutely looking at a fine to start. You
Okay.
don't start with jail, and the reason you don't start with jail is because you have nowhere to escalate from there. If you get a fine, you have a lot of room in terms of future violations, which in a case like this, you absolutely have to anticipate there's going to be future fines. The fines are then going to get raised. And then after the fines get raised, there'll be other penalties, which could include going to jail. I think that that's the appropriate remedy. I think that the judge does have a very interesting question to satisfy, though. When you think about the retweet of Fox News's Jesse Waters' claim about a liberal activist trying to get on the jury, that question begs the notion of whether a retweet constitutes an endorsement.
Mm-hmm.
I think that that really, when you're talking about violations of the gag order, does that come into play? Should it come into play? Those are questions that I am very interested in from a legal perspective to see how Marchand actually goes through. But to answer your question, if you're just talking about what it is to violate a gag order that's in place, starting off, we're looking at a fine, and
Mm-hmm.
then we're going up from there.
And does Judge Marchand at this hearing, because some things like the pundit class of people will see certain things, but lawyers look at it differently. Well, do you expect him to lay out a way to keep control of his courtroom, keep control of the administration of justice, and maybe even set a schedule like, hey, every next violation is this, so the whole country knows the next one after that it might be a day in jail. After that, it could be 3 days in jail. Do you expect that?
I think it'll be somewhere in between. I don't necessarily know that he's going to give his entire thought process an opportunity to be dissected and vetted by media and the public at large. I do think that he's going to make a statement that is firm and solid and definitive enough that people are clear that he is not messing around. because he's not. But I don't necessarily know that he wants to box himself in by saying that the next one is going to be this, because you don't know what that next one is.
Sure.
It could be something that's super egregious.
Hmm.
And then that type of punishment doesn't seem appropriate, or it could be something that perhaps may cross the line, but may not be worthy of, a more severe punishment. And so I don't necessarily know that he's going to want to box himself in, but I think he may allude to what the escalation steps or additional options could be. And we'll have to see how he, maneuvers and navigates that from there.
And that makes all the sense in the world, the way you laid it out. Because you're right. If he says your next thing, it's like a menu. If you do one more
Yeah,
thing, this is what happens. So, like, oh, I'll take it for that. But you're right. If it's really egregious, if he does something in the courtroom in front of the jury, that
right.
instantaneous kind of contempt could happen. I'm chatting with Charles Coleman, MSNBC legal analyst, former prosecutor. Look, I know you haven't seen all the evidence. We don't know how it's going in. We're going to start that next week. As a former prosecutor, though, from what you've seen in the pleadings and the pretrial, how does this case look in terms of strength, weaknesses? Like, I don't mean like a granular breakdown, but more in
Yeah.
the overarching sense of, is this a strong case, a medium case? Where does it fall?
Dean, I'm going to be honest, and a lot of your listeners may not love me for this, but I don't love this case. Of
Okay.
all the cases that are being brought against Donald Trump, I think that this is the most troubling and possibly where he has an opportunity for some wiggle room. I think that the different counts in Georgia, for example, give him some wiggle room as well. But with respect to this case, the issue is that in order to get to a felony, you have to be able to say that he was doing these things, these business record, basically falsehoods, in order to further another crime. And it hasn't quite been made clear what the other crime is. It seems like it may be some sort of campaign finance violation. But my point is, Alvin Bragg had looked at this, Cy Vance had looked at this, and they both declined. The feds had looked at this, and they all declined. They didn't decline because it was a strong case and they had other stuff to do. They declined because they understood that the legal theory of this case is a little convoluted. It's not exactly the strongest connection. You're kind of sort of duct taping different legal theories together in order to get to where you need to go. Now, is duct tape strong enough? Is duct tape strong enough to hold some stuff together? Yes, that's why we use it.
Right.
But is it what you want to rely on when you're going after the former president of the United States in literally an unprecedented prosecution? I don't know. So I don't love the case. I think that he has some very good lawyers here who
Mhm.
are experienced trial attorneys, and they are going to give the state some trouble. So, as a former prosecutor, look, I understand it. That's why you play the game. If you think you can make the case, you go at it, and if you don't, if you're not victorious, you're not victorious. But I will say for anyone who's listening to this, the details of understanding the indictment, what he's charged with, and then the elements of proof here do not make this at all anything close to a slam dunk of a case for the prosecution.
That's interesting. And I appreciate you breaking it down the way, you did. And your experience as a prosecutor is very helpful for listeners to see. It might, and at the outset, to be honest, this was never intended to really be the first case.
No,
Alvin Bragg thought the federal case would happen first. No one thought the Supreme Court would hold things up the way they have on the immunity argument. So we're going to have that argument next week. Getting back to the jury for a second here, 6 alternates in a case that's only about 6 weeks expected. Is that a bigger than normal amount? Is that typical?
it's typical. I mean, it's a little larger. I mean, usually you would have either 4 or 5, but it's
Mhm.
not. So it's not astronomically larger. But I think in this case, in a case like this, you really can't afford to run out of alternates, and you never know what's going to happen. I mean, you're talking about New York City. Literally, someone's kid could get sick, and they
Right.
can't come to jury duty, and then any number of things could happen. Someone is extremely late one day because of a subway derailment, and so they have to proceed. I mean, there are all kinds of things, and of course, you're not wishing bad on any of the jurors, but the
Sure.
ultimate, consideration that the judge has to take into account is they have to be as well resourced as possible to continue on in the event that there's something that happens, because you're not going to get a whole bunch of shots at this, and this is hard enough to do one time, let alone two. So I do understand why you have 6 alternates. I've been in a number of different trials, and it's not uncommon that I've had to use 1 or 2 alternates for various reasons. In a case like this, the other thing, Dean, that you have to think about is just like we saw one of the jurors who had been impaneled, or rather who had been sat, ultimately removed for being dishonest. There are a lot of surprises that could emerge throughout the course of this case. There are people who might come in and say that they've been intimidated, they no longer want to participate, they can't think fairly, just anything. And so, for that reason, again, to make sure that you're able to bring this trial to its conclusion, you need to have the requisite number of alternates and then some.
So do you think that there's a heightened look in the media? Everyone's talking about the heightened concern about jury potential tampering.
Yeah.
And even Judge Marchand, in the order we're doing protection, a gag order, cited the idea of potential of bribery or threatening. How real is that? Is it overblown, or is it erring on the side of just being safe? Or do you think there's a credible risk here, like you would in a mob trial or
I
a
think I
terrorist
think
trial?
I think that this is probably as high a risk of jury tampering as you might see. But here's the thing that I think people need to understand: it's going to come in a different form.
Mm-hmm.
I think the sort of organized crime, I'm going to pay you to throw this trial, or I'm going to make sure you live as long as you throw this trial. I don't necessarily know that we're facing that type of pressure, but I do think that the type of pressure that the juror who ultimately declined would face upon their identity being revealed, and then family, friends, enemies, frenemies being doxxed, things of that nature, that information getting out, I think that is a very real threat. I think the notion of, so I mean, the Washington Post, shame on them, put out an abhorrent degree of personal information about one of the jurors in such a way that it did not make it difficult for people to identify who she was within her circle. And that sort of thing, an inadvertent comment, an inadvertent reference that would potentially reveal something personal about one of the jurors. The judge, if I have one critique of him so far, it's that he did a lot for far too much personally identifying information to get into the record in such a way that some of these people might be identified. And in that way, I think the pressure could come. I think the pressure could come from, like I said, family, friends, social media, just the general conversation around it. It's almost impossible to avoid. So, if
Yeah.
you're a judge, you're going to tell your jury, hey, don't listen to the media, don't watch anything about this. That's once we get started, once this train leaves the station, that's going to be virtually impossible unless you sit around watching cartoons all day. And so, the type of
Right.
pressure we're talking about with jury intimidation, yes, I think it's very real as ever. I just think it's going to come in a different form.
Does a gag order to protect the identity of the jurors, like Donald Trump's not allowed to make statements about the jurors, will that expire when the trial ends, or can the judge expand it? Because, the fear is jurors on the other side of this being identified and being attacked, being on Fox News, and some people going after them later.
Yeah, that is pretty much going to expire at the end of the court case, and I don't necessarily know that there is a vehicle in place, at least not right now, for him to continue it. I think that prosecutors, Alvin Bragg's office, has to be extremely cognizant and careful, because if they do a bad job of protecting jurors in this case, they're going to put their line assistants, the ADAs that are trying cases day in and day out, in a very difficult spot. I worked in a gangs unit, and when I worked in the gangs unit, one of the most difficult things was to get witnesses to come forward, and I understood why,
Sure.
because there was limited protection that we were able to offer them. I mean, in some cases, we were able to put people up in hotels and keep them out of their neighborhoods for a little while during the course of the trial. But when the cases were over, they had to go back to where they were from. And so there wasn't much incentive for cooperating. And I think that, beyond the preservation of this trial, I think both Judge Marchand and Alvin Bragg have to be thinking about how do they create an environment where people who are watching this and think about civic participation are comforted, or at least feel safe deciding that they're going to show up for jury duty, not knowing what they.
Yeah, and it could have an impact on the future Trump criminal trials. If some juror or something happens to a juror in this case, does it make it harder for them to pick a jury, or for people to do want to be on jury duty in the future and go like, whoa, that juror got attacked or whatever. And I'm chatting with Charles Coleman here. Last couple of things, Charles. Trump, you mentioned he fell asleep. He fell asleep again today, the third day of this week trial. Does it mean anything, you get a sense to the jury if they see the defendant falling asleep? We can expect, I imagine he was going to fall asleep again in other dates of this trial.
Well, it's funny you say that because in order for juries to notice that the defendant is asleep, they've got to not be asleep themselves. I say that to say that, it's not uncommon that folks will nod off at trial. But of course, when you're the defendant, there's a different standard there. And that's another reason why I say he's going to snap. He's going to pop, and he's going to pop because someone who's not used to that and who understands what's at stake, which he does,
Sure.
uh, that is ultimately going to take a toll because he has no release, he has no outlet. And I mean, I guess he and his attorneys are going to have to figure this out. I don't know if he's a man who drinks coffee or Red Bull or 5 Hour Energy or any of those other.
I think it was Adderall. Wasn't his big thing? Wasn't his
Yeah,
choice, his cocktail of choice,
yeah,
Adderall?
yeah. He's going to have to figure something out, and he's going to have to figure something out because this is a process that's not getting any shorter. And it's not getting any lighter or low pressure. And so for a guy who claims to be in such great physical health, he's going to have to put some of that on display because even if other jurors fall asleep, for example, they're watching him because he's the one
Right.
on trial. And it's not a good idea or a good look for him to be nodding off in the courtroom. I mean, even if his attorneys, need to be smarter and say, Judge, can we get a recess or something?
I wish Biden would send him a pillow and a blanket and go like, if you're going to fall asleep during trial here because you don't have the stamina to do this. I wonder on another level. Look, I think if this is true or not, I've seen it too many cop shows and police shows that the defendant they put in the holding cell who goes to sleep is guilty, and the guy who stays up all night is innocent. And you wonder, and I know that's just from TV and stuff, but we live in a world where we've learned a lot about the criminal justice system from Law and Order, for good or for bad, and these TV shows. I wonder if his lawyers at some point have to have the judge say something like, just because my client's falling asleep doesn't mean you can't look into it one way or the other.
I mean, he can try. That would be an unusual exception, but in some respects, I think the court is not inclined to do that because the court's going to see him falling asleep. Quite frankly, is a little bit of disrespect to the court.
It is.
So I don't know that they're inclined to sort of ease the jury's perceptions of that around his guilt or innocence, regardless of the fact that they aren't necessarily connected.
Did you ever have a case where you remember defendants falling asleep, a criminal case where you were,
Absolutely,
yeah.
absolutely,
So it's
absolutely.
not as that, it's not as
It's
rare.
Listen, Dean, it's one of the types of things where if you can imagine, if you've ever, for anyone who, if you can, the best parallel I'll give it to for you and your audience is think about the first day at a new job when you're on and like no, you don't know anyone, you're sort of there, you're meeting everybody, so you want to have your best foot forward. So you're like super duper engaged as your best self and like conscious and your emotions are high, you learn everything's new, you don't even know where the bathroom is, but you're trying to pay attention and soak up the information, be observant, be present, be pleasant.
Mhm.
And then you get home and you're just like, and you almost want to collapse. It's like that. I mean, even for a trial attorney, the process is extremely grueling and it's mentally taxing. And I think that for Donald Trump, respectfully, given his age, this level of fatigue is not something he's used to experiencing. There's nothing like it.
And last thing, obviously the debate, should Trump take the stand or not? If Trump were to take the stand, that's going to be his choice. Whatever his lawyers say, if he wants to take it, who does it help more? Does it help the state more potentially if he takes the stand? Does it help himself? Is there a way he actually could help himself by taking the stand?
There's a small window that Donald Trump takes the stand and somehow helps himself. But even in that window, to answer your question very specifically, he still helps the prosecution more. Even if he helped himself on the stand, there's no universe in which Donald J. Trump gets on the stand and somehow within his testimony exonerates himself in front of 12 New Yorkers. That's just not going to happen. I think that it's really just a matter of him understanding what he's opening himself up to. And I think the Sandoval hearing, which is the hearing that ultimately decides what prior bad acts and to what extent uncharged prior bad acts are going to be allowed during cross-examination. Once he understands that, I don't think that he's going to take the stand because there are just things that he really won't be able to respond to. I mean, right now, for what it's worth, keep your bully pulpit on social media. People can't really respond to that. You can sort of create whatever narrative as you want about around your prior bad acts,
Right.
and don't go into court and testify under oath under penalty of perjury that you didn't do certain things that you know you did, and put yourself in a worse position.
And very last thing, because full disclosure, we're pre-recording this, and just learned a minute ago from my producers that the jury selection is complete.
Yeah,
They
they're
got the
calling you
alternates.
now. They're calling you right now.
So it's done. So just so people know, in the last minute, what's going to happen next week? Is it going to be opening arguments on Monday in all likelihood?
Sandoval hearing early on, likely,
And
and
that
then
has to do with Sandoval hearing, just so people know what that means quickly.
that's the hearing that will allow the prosecutors to lay out whatever prior uncharged bad acts they have in front of that they intend to present on cross-examination if the defendant testifies, and then allows the defense to make a decision as to whether they want to put certain witnesses on the stand. But I expect opening statements no later than Tuesday.
Wow. Well, Charles, thank you for squeezing us in between all the hits on MSNBC. Have a great weekend. I look forward to chatting with you in the future, brother.
My man. Thanks a lot, Dean.
Take care.